The Hensley property deed recorded in the Harlan County Courthouse as Deed Book 13, page 176, proves that the Hensley family owns the most senior portion of the patent for the tract of land described in the deed. It reads as follows. A certain tract or parcel of land lying in Harlan County, Kentucky, on the Poor Fork of the Cumberland River and bounded as follows to wit. Beginning on the top of the ridge, above the right-hand fork of the Big Branch, this is in relation to the flow of the Poor Fork River on the upriver side of that creek, Big Branch, on the line of an 1,800-acre survey made in the name of James Turner. Thence, down the top of the ridge to the north line of the 200-acre survey patented to James Turner. Now this description stops and refers to the patent of the 200-acre James Turner, and it states, this survey begins in the head of the left-hand fork of Bailey Creek, just as it reads on the 200-acre survey. Thence westwardly with the north line of the 200-acre survey to the top of the ridge below the right-hand fork of the said Big Branch. Thence southwardly up the top of said ridge to the 1,800-acre survey. Thence with the 1,800-acre survey to the beginning. The Hensley family hopes this presentation provides proof that the Hensley family heirs hold title to this tract because they own the oldest patent for this tract by deed in 1907 by their grandfather, Lloyd Hensley. The purpose of this video is to describe the boundary line discrepancy between the Hensley family property and Kingdom Energy JRL coal property. The metes and bounds of both properties include names of rivers and ridges, making it necessary to understand a little about the geography of the Black Mountain Ridgeline. The Cumberland River starts in Harlan County. The Poor Fork of the Cumberland River is the name of the smaller river that flows from east to west and feeds into the Cumberland River. The Clover Fork of the Cumberland River also flows from east to west and feeds into the Cumberland River. You can see here that the Black Mountain Ridgeline, the highest ridgeline in Kentucky, runs between the Poor Fork and the Clover Fork. These rivers and ridges are mentioned often in the deeds owned by the Hensley family and by the surrounding property owners. The Hensley family owns land on the Pine Mountain side of Poor Fork and on the Black Mountain side of Poor Fork. No coal exists on the Pine Mountain side. Coal is only on the Black Mountain. In 2018, JRL Coal contacted the Hensley family requesting to mine coal on their property. After negotiations with the Hensley POAs, the Hensley family signed a mining contract in February of 2019. The attorney for JRL Coal handled the signing of the lease. JRL Coal said they would only be mining on one of the Hensley family tracts. Deed Book 36, page 487. This is the only deed JRL requested to be included in the coal lease. Hensley family members explained that they had several other deeds. The Hensley family asked for mine maps outlining this area before the signing of the lease. The attorney assured the family that they would receive mine maps before mining began. The attorney explained that they were delayed and had equipment and employees ready to mine that day. He assured the Hensley family they would receive mine maps and the first royalty payment within 1 month, and the attorney stated that they needed the signed lease in order to plan and start mining. 3 months went by without any communication, even after repeated calls and emails from the Hensley family and the Hensley family attorney. 2 members of the Hensley family eventually drove to Harlan to the coal office in July of 2019. Employees of JRL Coal happened to be discussing the Hensley family property and the mining that was taking place when the family members arrived. While they were there that day, the Hensley family attorney and other Hensley family members were able to discuss the maps and royalties together by speakerphone. At this visit, JRL Coal employees outlined this area of the Hensley family property on the coal map. JRL Coal representatives explained that this area, outlined in green, had at that time just been mined and was the area for which the Hensley family would be receiving royalty and wheelage payment. JRL Coal representatives further explained that this area in red was the next area to be mined. The Hensley family members shared that the property line placement did not look correct and asked what source was used for the placement of the property boundary line. JRL Coal representatives stated it was the Hensley neighbor who gave them the maps, but then when questioned, they said that they actually got the maps from the PVA office. The Hensley family have been told repeatedly that determining boundaries for mineral mining is not a reliable or legal use of PVA maps. Per the Hensley family request, JRL assured the family they would double-check the Hensley property lines by deed in relation to the mining plans and get back with the family to discuss the correct placement of the lines. We were thankful that it was a cordial, friendly meeting. A royalty check was distributed the day after this visit for the area circled in green. JRL Coal then contacted the Hensley family, asking for an unreasonable discount on coal mined in this area in red, and required that in order to receive any payment, Hensley POAs must sign a separation agreement that stated the Hensley family would not hold JRL responsible for more royalties, wheelage, or damage that may have occurred on the property until the end of time. This naturally caused the Hensley family to be concerned about the amount of coal that was actually mined on the Hensley tracts of land, and concerned about any possible damage to the surface. At this point, the Hensley family sought the advice of a surveyor and an attorney. A decision was made to file for an arbitration to discuss the property lines with JRL Coal. The Hensley family then learned that JRL and Kingdom had been sued by HBKY. After spending over $60,000, the Hensley family members realized there was no guarantee that they would receive the funds they were owed, and therefore the Hensley family could not justify spending any more on attorney fees. JRL had told the Hensley family that after new measurements, they determined that there was actually no coal on any Hensley property, and therefore the Hensleys are not owed any further payments. After working with an attorney and surveyors, the Hensley family seeks to correct the placement of a property line that was incorrectly moved too far north by a surveyor for the Cumberland Coal Company from New Jersey, who previously owned the current Kingdom JRL property. Lloyd Hensley, the grandfather of the Hensley family, owned the Hensley property until his death in 1953. This land was given to him by his parents and siblings, and then handed down to his 7 children, and now on to his grandchildren and great-grandchildren, the current Hensley heirs. In the early 1900s, when Lloyd Hensley was in his 20s, he was part of a property line correction process. Conveyances had been made on the opposite side of the ridgeline, which encroached on his land and on the neighbor's property line as well. Due to a patent deed that is older than the surrounding deeds, there was an overlap due to incorrect survey measurements. In order to understand this discrepancy, it's necessary to understand the precedent set in Kentucky, making the oldest or original patent deed the governing patent. If there's a discrepancy of the property lines, it's the oldest patent that governs. While this precedent works in most cases, it does not work in this specific patent line discrepancy. Typically, unless there's a fence line, structure, or dwelling, the property owner with the oldest original deed, called a patent, wins the dispute. This means that even if it has been established by previous owners where the proper placement of a property line is, future landowners can claim land of their neighbors, taking acreage that had been part of the family's property for decades or even centuries. The Hensley family believes they have an exception to this land patent precedent. In the late 1700s and early 1800s, military veterans were given land warrants as payment for their military service. The U.S. did not have the money or land to pay their early American veterans. These land warrants were not given for a specific piece of land. They were a kind of ticket or promise that the soldier would be able to use at a later time to claim a tract of their choosing once land was made available by the U.S. government. Later, after this era, a system by which citizens could go and buy land warrants at their county courthouse was enacted in 1835. The front page of the Kentucky Secretary of State website provides access to laws and statutes concerning this land warrant process. There's also a database for researching patents and land grants. On the front page of the county court orders, it reads, "In 1835, the Kentucky General Assembly modified the system for patenting unappropriated land in the Commonwealth. Prospective landowners purchased orders or warrants from the county court, authorizing the county surveyor to survey a tract of unappropriated land for a patent application. The total acreage could not exceed the amount specified in each warrant, and the land had to be located within the county issuing the warrant. More than one warrant could be used for a particular survey." Notice that the total acreage could not exceed the amount specified in each warrant. This law will become important when resolving the property line dispute. The second step involves reserving the land to be surveyed. The entry books were and are kept in the county courthouse. Warrant holders would file an entry to reserve land for a survey by filing their name, type of warrant, location of the land to be surveyed, and the warrant number. The third step involves a surveyor who accurately depicts and describes the tract of land to be patented using a plat drawing, date of the survey, the warrant number, measurements, and the watercourse. A team works with the surveyor that includes a chain carrier, director, and marker. In step 4, the completed survey was then sent to Frankfort, where a land grant document was prepared with formal language and a seal. Land grants include the name of the patent recipient, the type of warrant used, the warrant number, the county, the watercourse, the tract description, the survey date, the grant date, and the signature of the governor. In this step, title was conveyed to the grantee and a patent number was issued. A copy was then recorded in the Land Office grant book in the state capitol in Frankfort, Kentucky. A land patent is the first deed that can then be sold or conveyed to the next landowner. The next conveyance document is called a deed. A land patent is a process by which the government grants an individual or entity ownership rights to a specific piece of land that has not been previously allocated for ownership. It serves as legal proof of land ownership for a tract of land for the first time. This original title to the property becomes the first document in a chain of title for that specific property. The patentee is now free to build and use the land once the patent is granted. When JRL submitted this document in 2021, they stated, JRL had a survey performed in response to your client's arbitration demand. The survey did not support the claims made in your letter of May 17, 2021. Instead, the survey shows that JRL has overpaid the Hensley heirs. When questioned, JRL representatives stated verbally that they had used the north line of the James Turner 1,800-acre patent to determine the Hensley family south property line, and that they were mistaken when they negotiated a coal lease with the Hensleys, and that there's actually no coal on the Hensley property. If this were true, the line would be placed here. Then, in October of 2023, JRL submitted a drawing without a surveyor name or stamp placing the line here. This naturally caused the Hensley family to request a careful examination of where this patent should be placed according to the original survey. This is the base standard chosen by JRL for their reasoning for keeping and selling this amount of coal in yellow. The Hensley family contends that this is their property by title of 2 deeds that include the purchase of this exact same tract 2 times. Why were 2 closings and 2 conveyances needed for this same tract of land? Because an overlap of patents was discovered, and the Hensley patriarch, Lloyd Hensley, wanted to ensure ownership for his descendants by purchasing this tract a second time. Now, this tract is being unlawfully taken away from the Hensley family. The Hensley family has repeatedly asked to meet and see the reasoning for JRL's placement using deeds owned by the Hensley family that are recorded in the Harlan County Courthouse. The James Turner 1,800-acre patent is the most important component when determining how much coal is owned by the Hensley family. Placing this patent correctly involves 3 elements: the inclusion of this patent and adjacent patents recorded in the Secretary of State Land Office in Frankfort, Kentucky, the inclusion of deeds recorded in the Harlan County Courthouse describing the tracts that came out of these patents and thus narrowing down the accurate placement of this James Turner 1,800-acre patent and the surrounding patents, and the correction deeds filed for the exact same property lines that are recorded in 13 deeds in the Harlan County Courthouse by 27 landowners, 2 trustee attorneys, with the approval of the Harlan County Clerk, in a correction process called a moiety. JRL Kingdom and HBKY seem to have skipped this community moiety property line correction process and left out its ruling when determining the Hensley South line. Our hope is that this background information helps to better understand the main elements of this property line dispute and lead to a fair and accurate outcome. This presentation is for use with potential future mediation, arbitration, evidentiary, or court hearings. It's also intended for the Hensley family members as they work together to provide details of real estate law, land surveying, and coal mining
in relation to the Hensley family property deeds they each share with over 30 family members. As mentioned, the north line here of the original deed, called a patent, is the source of the problem. It is the entire reason for the JRL Kingdom Hensley property dispute. It is difficult to understand why the surveys submitted by both JRL and HBKY do not include the entirety of this most important patent deed. The placement of this 1,800-acre patent deed dictates how much coal is owned by the Hensley family and how much is owned by JRL Kingdom. There is no way to demonstrate the proper placement of the north line of this patent deed without including the beginning point and all 6 lines of the patent survey. This 1,800-acre patent in the name of James Turner Sr. is the first deed in the chain of title to the present day. In this case, it was for the Turner family. This is why it's called a patent deed. It is the first time this land was legally owned by a U.S. citizen. It was granted to James Turner Sr. on July 5, 1846, by the governor of Kentucky. We do believe that a detailed and complete view of all 6 survey lines, along with a full explanation of the history of this patent and the chain of title subsequent to the conveyance of this patent in the will of James Turner Sr., are needed to resolve this dispute fairly. We will show that placing the 1,800-acre patent granted to James Turner Sr. here in this location is based on the description and correction of a measurement mistake of over 1,000 acres that was made in 1887 by a survey when a tract of this land out of its northwest corner was sold to a coal company named the Cumberland Valley Land and Mining Company from New Jersey. The neighboring tracts of land were encroached upon, resulting in the adult children of James Turner Sr. and their neighbors working together to correct the mistake. They hired 2 attorneys to correct the mistake as demonstrated by 13 correction deeds involving 30 people who agreed to be involved in the community moiety correction process as evidenced by their signatures on the moiety correction deeds. Why did these people work together to correct the property line instead of using the precedent of the most senior patent rules that would have resulted in the loss of acreage and minerals? These people who owned these patents that were passed down to them were neighbors and related family members who evidently had great respect for one another. They hired 2 attorneys and resurveyed the land, corrected the north line, and made sure that everyone involved was compensated and treated fairly. 2 surveyors have shared with the Hensley family that they have put in over $6,000 of work each, but that the community moiety element prevents them from providing their professional decision in the property line dispute. They have explained that they are not familiar or trained on the specifics of community moiety resolutions, and therefore they have shared that the assistance and ruling of a judge is required. Both surveyors said it would take an additional $100,000 at least and another year to make sure the survey is correct. Perhaps this is why the surveyors for HBKY and JRL have only provided a partial survey instead of full surveys. Without the beginning point of this James Turner patent placed correctly and included in the survey, there is no way to make sure that the north line here is correct. The landowners of the late 1800s and early 1900s faced this challenge as well, as illustrated by the legal process in which they all chose to participate, called the moiety. As mentioned, this process took place beginning in 1907 between 30 people with their 13 conveyance deeds that are duly recorded in the Harlan County Courthouse. If the decision is made to go along with the new placement submitted by the surveyors of JRL and Kingdom Energy, as well as HBKY, it would arbitrarily exclude and reverse the correction made by the landowners and attorneys involved in these 13 deeds in the years 1907 to 1914. If the new property line placed by the surveyors of JRL Coal and HBKY is permitted to rule as the new property line, it would seem also to require informing the county clerk of the exclusion and deactivation of 13 deeds in the deed room. Deactivating or invalidating these 13 property deeds would also bring into question the taxes for this property. If the south line of the Hensley family is moved north by the surveyors of HBKY and JRL without evaluation of the entire circumference of the 1,800-acre James Turner Sr. patent and the inclusion of the community moiety correction, would the Hensley family be compensated for the additional taxes they have paid for over 100 years? Would future property taxes be adjusted as well? Taxes for approximately 30 less acres over 100 years would be challenging to calculate, but a valid request if The conclusion of the dispute is to take acreage and minerals from the Hensley family that they have owned and paid taxes on for over 100 years. Again, it is the view of the Hensley heirs that this dispute could have been resolved easily 4 years ago if J.R.L. Cole would have given them a chance to show them their property deeds. The Hensleys have asked for a meeting, then mediation, then they asked for arbitration. All requests have been denied. The original mistake that was made by the Cumberland Valley Land and Mining Company was a part of a trend of mistakes, but the Hensley family is stating that the practices of J.R.L. Cole are in no way related to the mining practices of the Cumberland Valley Land and Mining Company, who mined in Harlan County in the late 1800s and early 1900s. Coal mining in Kentucky started in the early 1800s. By 1843, coal production had reached 100,000 tons. In 1879, coal production surpassed 1 million tons. The Black Mountains have contributed a significant percentage of the United States electricity supply for now almost 2 centuries. Why is this important in the boundary dispute in the communities of Putney and Evarts of Harlan County, Kentucky? The coal companies of the 1800s that moved in to mine the Kentucky coal bought up the land and often used faulty measurements, especially when using poles and chains on uneven and steep terrain. The initial survey mistake made by the Cumberland Valley Land and Coal Company in 1888 on the boundary measurement to the south of the Hensley property caused a domino effect of mistakes that are still causing problems today. This company, as listed in the grantee index books in the Harlan County Courthouse, bought hundreds of thousands of acres in Harlan County. This presentation demonstrates how one such error made by the Cumberland Valley Land and Coal Company was corrected by the community, and it is this correction that will resolve the current dispute between the Hensley family heirs and J.R.L. Cole Kingdom Energy. It is impossible to understand this property line dispute without first understanding the basic land elements that the original landowners, who were neighbors and family members, surveyed and conveyed to one another. The 2 surveys submitted by J.R.L. Cole and HBKY failed to accurately and comprehensively include the James Turner Sr. 1,800-acre land patent. This patent is the determining factor in the property line dispute between J.R.L. Cole and Kingdom Energy. The dispute covers approximately 600 yards. The amount of coal estimated to have been mined and sold in this dispute has been estimated by Mike Francisco of Pike Tech to be $28 million. At a typically negotiated 7% royalty with a coal lease would mean a difference of approximately $2 million for the Hensley family. If the James Turner Senior patent is placed here, as the surveyors for JRL and HBKY have placed it, this amount of coal would belong to the Hensley family. If the James Turner Senior patent is placed here, it would mean this amount of coal would belong to the Hensley family. When we share our documents that included this moiety, professionals charge us up to the point of the moiety, then stop before resolving it. It is for this reason that we are submitting this presentation and our documents to you. We believe if JRL would have simply honored our request to show them our position and documents, we feel this dispute could have been resolved in 2019 when mining was taking place. Instead, they have avoided and delayed and cost the Hensley family inordinate expense and time trying to prevent JRL from keeping our property and payment. JRL Coal and HBKY each submitted a survey in the joint share file as data supporting their view that the Hensley family is not owed for more coal mined and sold along this ridgeline on the Black Mountain Ridge between Putney and Evarts communities in Harlan County, Kentucky. The survey submitted by JRL Coal does not include a date, a surveyor name, or a surveyor stamp. The surveys submitted by both JRL Coal and HBKY fail to comprehensively include the full circumference of the James Turner Sr. 1,800-acre patent number 8197. This James Turner Sr. patent, granted on July 5, 1846, is the determining factor in the property line dispute between J.R.L. Cole, Kingdom Energy, and the Hensley family. The dispute involves a property boundary here that covers approximately 600 yards. This is the property owned by J.R.L. Cole, Inc. and Kingdom Energy. The tracts outlined and shaded in dark red, orange, and green here are the 3 Hensley tracts from the 3 Hensley family property deeds recorded in the Harlan County Courthouse. This area, outlined and shaded in white, is the area owned by J.R.L. Kingdom. The amount of coal estimated by Mike Francisco of Pike Tech that has been mined and sold by J.R.L. Coal is the area here is worth $28 million. A typical coal lease, negotiated at 7% royalty, would mean a difference of approximately $2 million for the Hensley family that, from their point of view, was saved and protected by their grandparents, Lloyd and Mary Hensley, as a gift of love and support for their children, grandchildren, and great-grandchildren that now number over 150 descendants. Grandpa Lloyd was well aware and spoke often of the existence and value of the coal in this area of the Hensley property high on the Black Mountain ridgeline. If the James Turner Sr. patent is placed here, as the surveyors for JRL and HBKY have placed it, this amount of coal would belong to the Hensley family. If the James Turner Sr. patent is placed here, it would mean this amount of coal belongs to the Hensley family. This presentation will show that the current property line discrepancy was already resolved in the years between 1906 and 1914 in a process called a moiety. This process was handled by 2 trustee attorneys named John B. Clay and H.C. Carter, and 27 neighboring landowners. These 2 surveys, recently submitted by JRL and HBKY, seem to attempt to reverse the legal resolution that was filed and is recorded in the Harlan County Courthouse in 13 separate deeds involving 30 people. Neither HBKY nor JRL mention any of these 13 correction deeds from this same exact 600-yard property line of this formal community moiety resolution in their survey or their reasoning for their placement of the property line that is the north line of the patent deed in the name of James Turner Sr., number 8197, with a grant date of July 5, 1846. This legal community problem-solving process, called a moiety, is integral to resolving the dispute because it was used to correct the property line that encompasses the entirety of the exact same property line in the dispute today. As mentioned, there is a potential for over $2 million of difference for the parties in this dispute, making it important that it is examined carefully and placed accurately for a fair outcome. The red marker here marks the highest point on the Black Mountain ridgeline, the highest point in Kentucky. This line in the landscape shows the Pine Mountain ridgeline. The Black Mountain ridgeline is not as defined, but it is noticeable here. The Black Mountain ridgeline runs from east to west, south of the Pine Mountain ridgeline. This perspective looking south gives a good perspective of the Hensley farm area, looking up at the Black Mountain side of their Hensley property. The Hensley family tracts on the Black Mountain are recorded in the Harlan County Courthouse. This area here is where Lloyd Hensley and his wife, Mary Jane Hensley, lived along the Poor Fork River on the north side of the Black Mountain ridgeline. Lloyd and Mary Jane Hensley's children sold the 10 acres of farmland in 1973. It is now a playground and horse park. We are thankful that we can still go and walk and play there. Lloyd and Mary Jane Hensley's 7 children then sold this area here of 4.843 acres to the Harlan Machine and Electric Company. This tract here, that used to be owned by Lloyd along with his parents and siblings, was passed to his brother Alan. It was sold and is now the Harlan County Campground, owned by the Foster family. We recently enjoyed staying at the campground, where we were able to access 4-wheelers and walk our Hensley property south and up to the ridgeline. Notice how the ridges run from the river up to the Black Mountain ridgeline. These ridges make natural landmarks for boundary descriptions on the property deeds. These ridges that run from the high mountain ridgeline of the Black Mountain down to the river are often called river ridges. The creeks and branches run in between the ridges in the low place, or hollow, or holler as we say in the mountains. The river, named the Poor Fork of the Cumberland River, can be seen here. It runs from east to west. The head of the creeks are where the creeks begin, high on the main ridge, in this case, the Black Mountain ridgeline. The term head of the creek refers to the source or starting point of a creek or stream. It is the place where the watercourse originates, typically in a high elevation like a mountain or a hill. Describing the head of the creek is a way of specifying the location where the water flow begins. In a broader sense, it's a term used in geography and land descriptions, in deeds and other maps to indicate the starting point of a water feature. It is often relevant in legal documents or discussions related to land use and property boundaries. The mouth of the creek refers to the point where a creek or stream meets a larger body of water, such as a river, lake, or another larger branch or creek. It is the opposite of the head of the creek, which signifies the source or starting point. The mouth is usually at a lower elevation, and this term is commonly used in geographic and land descriptions to denote the endpoint of the watercourse. In legal and property contexts, understanding the location of the mouth of a creek is significant for defining land boundaries and water rights where the creek empties or flows into a larger body of water. In the case of the creeks on the Hensley property, the head of the creeks and the branches are here in the high elevation. The mouth of the creeks are here, with the creek emptying into the Poor Fork of the Cumberland River. Why is all this important? Because a lack of awareness about these simple concepts used by humans for thousands of years has contributed to some of the confusion in this property line dispute. It is important to note the measurements using perches, poles, and chains, or feet called metes and bounds, are not always necessary when describing a tract of land in property deeds. The use of natural landmarks or monuments, such as rivers, ridges, or existing structures, can also be a legally valid way to provide a clear and unambiguous way to identify the property's boundaries. If natural landmarks and terrain features are permanent and well detailed in the description of the tract of land in the property deed, the deed is equal to a deed that uses metes and bounds for measurement. In other words, both kinds of deed descriptions, landmarks, metes and bounds, are all well used and equally legal methods of describing the boundaries of land in deeds recorded and filed in courthouses across Kentucky and the United States. The key is that the description in the deed must be specific enough to allow a reasonable person to determine the exact location and dimensions of the property. The Hensley family argues that these ridgelines and creeks here on this, the highest ridgeline in Kentucky, have been here for thousands of years and therefore provide a clear and unambiguous landmark that allows for reasonable people to determine the exact location and dimensions of the property. Of particular importance for the Hensley family property deeds is this creek named Big Branch. Big Branch, with its right-hand fork, is highlighted here in blue. The head of Big Branch left-hand fork is here. The head of right-hand fork of Big Branch is here. This creek has retained its name, Big Branch, on deeds dated back to the 1800s up to the present day. Arrows have been inserted to show the direction of the water flow going downhill and into the river. The creek highlighted here is called the Lower Branch. It is situated on the downhill slope of the main river in relation to the downhill flow of the Poor Fork River. There are different versions of why this river was named the Poor Fork of the Cumberland River. It runs for over 30 miles from east of Partridge, Kentucky, west to downtown Harlan, where it flows into the Cumberland River. The Poor Fork contributes greatly to the picturesque landscape of this region. Understanding these geographic features is essential as the names and descriptions in the deeds are ultimately linked to the ridges, the creek names, and the flow of the river water. Rainfall onto the land flows down from the ridges and into the creeks and branches, continuing downstream to merge into the Poor Fork River and on to the Cumberland River, the Ohio River, the Mississippi, and on to the Gulf of Mexico. One would think this is obvious, but it's surprising how difficult it is for some to recognize and view these natural features as valid and legally binding when they are natural monuments that have existed longer than humanity itself. The Fork River flows in a westerly direction downhill, which is why this creek is aptly named Lower Branch. These creeks going in this direction are lower than the creeks upriver. Upper Branch, as the name suggests, is situated on the higher side or upper side of the Big Branch. The ridges as well are on the upper side of a creek or the lower side of the creek in relation to the river's flow. Powell and Mose Branch, as well as Rock Branches here, are located on the west side of Lower Branch on the downhill flow of Poor Fork. The amount of coal at the top of Big Branch and Lower Branch has been well known for many decades now. Neighbors of Lloyd and Mary Jane Hensley sold their tracts of land to the predecessors of Kingdom and J.R.L. Cole many years ago, but Lloyd knew the accurate value and held on to his tract along the ridge to keep the minerals and the rights for the land intact to pass on to his children, grandchildren, and great-grandchildren for the day that advances in equipment would allow for the responsible underground removal of coal. It is important to remember that from this perspective, we are looking south, the same direction that the Hensley family looked when viewing their Black Mountain Ridgeline property from their farm. Notice how distinct ridges separate each of the creeks and branches. Specific ridges are described clearly in the property deeds here and throughout Harlan County in this era by naming them in relation to the creeks and branches. This ridge, for example, is referred to as the Fork Ridge in deed descriptions because it is the ridge that runs between the right-hand fork and the left-hand fork of Big Branch. It is highlighted here in green. This ridge is called the ridge between the right-hand fork of Big Branch and Lower Branch. This ridge is called the ridge between Lower Branch and Mose Powell Branch. The property neighboring the Hensley property to the east has been developed into a campground and four-wheeling trail park. Hensley property on this Black Mountain side encompasses 3 deeds all recorded in the Harlan County Courthouse. These are the 3 tracts owned by the Hensley family, the descendants of Lloyd and Mary Jane Hensley. Deed Book 13, page 176, Deed Book 187, page 377, and Deed Book 36, page 487. The Black Mountain Ridgeline lies at the south boundary of the Hensley property line. It can be counterintuitive to think that this is north, but standing on this highway looking up at the ridge is actually looking south. Notice how the creeks begin at the high ridge and flow down to the river. These creeks and branches do not go over the ridge line, as that would be flowing uphill. This detail will become very important on the other side of the ridge when correctly placing the oldest patent deed on the ridge line in this area. When we view this ridge line looking north, you will notice 4 main creeks and 4 ridges. It is necessary to remember these creeks on this side of the ridge, as well as the creeks and ridges on the north side of the ridge, in order to solve the simple geometry riddle that defines the property dispute between J.R.L. Kingdom and the Hensley family. The ridges and creeks on this south side of the Black Mountain Ridgeline are easy to remember because Bailey Creek here has 3 forks, the right-hand fork, the middle fork, and the left-hand fork. These are mentioned in many deeds as the right-hand fork of Bailey Creek, the middle fork of Bailey Creek, and the left-hand fork of Bailey Creek. They are highlighted here in blue. This creek is called Turner Branch. It is to the west of Bailey Creek. In property deeds, this ridge here is called the ridge between the right-hand fork and the middle fork of Bailey Creek. This ridge is called the ridge between the middle fork and the left-hand fork of Bailey Creek. This ridge here is called the ridge between the left-hand fork of Bailey Creek and Turner Branch. Bailey Creek and Turner Branch flow downhill and south into the river named the Clover Fork of the Cumberland River. The Clover Fork River runs east to west, the same direction as the Poor Fork River on the north side of Black Mountain Ridge. please keep in mind that the water in the creeks on the north side of Black Mountain Ridgeline, where the Hensley property lies, flows north, downhill, which can be counterintuitive when looking at a map. This area outlined in gray is the approximate area under the surface where coal was mined and sold by JRL Coal in 2019 and 2020. From the Hensley perspective, this was a gift that was saved by Lloyd and Mary Hensley for their future generations. Again, we believe this problem could have been resolved before mining started when the Hensley family requested a meeting to show the accurate Hensley deeds filed in the Harlan County Courthouse. After 4 years, there has still been only delays and dodging for this meeting. Placing patent deeds can be similar to placing puzzle pieces. In theory, the first person to file an entry with their land warrant to have a survey done and then have a land grant completed should then not have any future surrounding neighbors' patents that overlap their property lines. Candace Atkins, the former Land Office Director in the Secretary of State's office, in her Kentucky Land Patent Process presentation, shares that other states have developed patent maps, but Kentucky does not have a patent map. Because of this, there are many lawsuits filed over property line disputes based on discrepancies in the placement of the original patent. As mentioned, surveyors in the early days were held financially responsible if they shorted the patentee on chains, so often they would add to the survey. This has led to countless patent disputes that lead to litigation. These overlapping patent issues occurred often, and therefore several methods for resolving patent overlaps developed. Sometimes the landowners resolved the overlap through informal compromise. Sometimes the correction occurred through litigation, as seen in this example in 1907, when this patent of 86,000 acres overlapped several patents. This case went to the U.S. Sixth Court of Appeals to resolve the overlaps. In the case of the ridgeline between the Hensley patents that overlap, the correction took place using a legal process called a moiety. This correction, as stated, already took place in the years 1907 to 1914. Therefore, there is no reason to relitigate the issue and pretend like the problem was never resolved. It was resolved, and the line was placed through compromise and compensation to all the landowners involved. Now it seems that HBKY and JRL would like to reverse the decision and ruling made by these landowners, attorney trustees, and the county court clerk during these years. The main events involving the placement of the property lines and the community moiety resolution process is as follows. Number 1. James Turner Sr. bought a warrant for 3,000 acres in 1845. The law that established a means by which citizens could buy unused land from the county court was enacted in 1835. It stated that the total acreage could not exceed the amount specified in each warrant. Therefore, James Turner Sr. could not survey and receive more than 3,000 acres total. Today, this fact is included on the front page of the Secretary of State Land Office County Court Orders website. While it is true that surveys would sometimes measure in excess of the warrant amount, we will demonstrate that the mistake that was made and corrected was a measurement mistake of over 1,000 acres, making it necessary to correct the survey lines in 1888. The surveys that JRL and HBKY have now submitted appear to revert back to the incorrect survey lines that measured the James Turner 1,800-acre patent to an area of over 2,800 acres, making this tract of land in his patent more than 1,000 acres more than was purchased at the county courthouse by James Turner Sr. James Turner Sr. had passed away by the time the mistake was made. We will show how all of James Turner's adult children and their spouses corrected and participated in this correction in the community moiety resolution process. 12 days after James Turner Sr. bought the land warrant at the Harlan County Courthouse for 3,000 acres, he had 2 surveys done. The 1,200-acre survey and patent was granted to James Turner Sr. here. The 1,800-acre survey and patent was granted to James Turner here, totaling 3,000 acres. The 1,800-acre patent started here on the point of a ridge 60 feet from the road, beginning at 2 white oaks, Chestnut Beech, and Dogwood on the point of a ridge on the north side of said fork, about 40 poles from the road, then north 33 degrees east 24 poles to 2 maples. Then north 5 degrees east, 30 poles, to a white oak, 2 dogwoods, birch, and maple. Then north 63 degrees east, 700 poles to a stake. Then north 24 poles west, 640 poles to a stake. Then south 60 degrees west, 740 poles to a stake. Then south 24 degrees east, 640 poles to the beginning. This website, recommended by the Secretary of State's Land Office, accurately measures a tract of land and places it according to where the user locates the beginning point. We will demonstrate using the Hensley patent that sits next to and to the north of the James Turner Sr. 1800-acre patent how to use this program. Lloyd Hensley's parents bought this patent along with 5 other tracts in a deed recorded in the Harlan County Courthouse on December 29, 1891. This deed was passed down to Lloyd Hensley and his siblings. This patent in the name of Sam Howard, the Hensley's great-great-grandfather, was granted to Sam Howard on March 20th, 1868. The cause for this patent read, situated in said county on the north side of the Big Black Mountain on the waters of the Poor Fork of the Cumberland River and bounded as follows to wit, beginning at a hickory beech and ash standing on the west side of a branch that was made a conditional line between Howard and Dixon, thence south 14 degrees east 26 poles to 2 buckeyes, thence south 38 poles to a linn, thence south 16 degrees east 20 poles to a white walnut, thence south 40 degrees east 100 poles to a stake, then south 60 degrees west 208 poles to a stake, thence north 25 degrees west 170 poles to a stake, thence north 60 degrees east 208 poles to the beginning. Putting the calls into the online program takes 3 steps. 1. Put the calls into this field and select the correct measurement translation. 2. Move the flag to the approximate location of the beginning point. 3. Hit enter. Then this KML file can be easily transferred to a Google Earth map where the correct location can be adjusted. As you can see, these early patent surveys were not part of an exact science. There continues to be a need to this day to determine what is fair and legal using several factors. Correctly placing the south line of the 200-acre Samuel Howard patent and the north line of the James Turner 1800-acre patent will provide the resolution for the JRL Kingdom and Hensley family property dispute. Since the James Turner 1800-acre patent is the oldest of the 2 patents, we will focus on it first. 2. When James Turner Sr. died in 1862, his children each received a portion of these 2 patents, along with some land from their grandfather, William Turner Sr., the father of James Turner Sr. Moses Turner, the 8th son of James Turner Sr. and Elizabeth Clay Turner, received through his father's will this northwest corner of the James Turner 1800-acre patent. 3. 11 years later, on August 18, 1873, Moses Turner sold this tract from his father's 1800-acre patent to his older sister Louisa and her husband, who was a Civil War Union veteran and Kentucky congressman named Chadwell F.C. Nolan. The deed from this conveyance is recorded in the Harlan County Courthouse in Deed Book G, page 3. In this deed, the land description includes the north line of the James Turner 1800-acre patent without the measurement of poles, chains, and directional calls. However, you will notice that the north line continues to the northwest corner, hitting at the ridge between the left-hand fork of Bailey Creek and Turner Branch. It reads, beginning with the cross fence above where James Turner Sr. deceased lived, the line between James Turner Jr. and Moses Turner, then straight with the cross fence into the Big Black Mountain to said Moses Turner's north line, then down with said north line to the dividing ridge between Bailey Creek and Turner Branch, then down with said dividing ridge to a mud hole where William Stanton now lives, now to the Clover Fork. Now, of course, we don't know where William Stanton lived, even though we hate to hear he lived in a mud hole. We do know where the Clover Fork is, and we do know where the ridge between the left-hand fork of Bailey Creek and Turner Branch sits. It is a landmark that has been there for at the very least 1,000 years. Now you will remember that the north line of the patent reads south 60 degrees west. The people here that lived on this land were all family members and farmers. They clearly knew the proper placement of the property lines, making it 1,800 acres, using fences and ridges. The line could be here, or it could be here. We will see that the definite placement is established in the descriptions that were included in the subsequent deeds when this tract was sold and eventually involved the community moiety process. 4. Louisa Turner Nolan, daughter of James Turner Sr. deceased at this point, who was the original patent holder, and her husband Chadwell F.C. Nolan, the congressman from Kentucky, kept this tract in the northwest corner of the James Turner 1,800-acre patent for a little over a year. They then sold this tract to Louisa's cousin named William B. Kelly on October 31, 1874. This deed is recorded in the Harlan County Courthouse in Deed Book G, page 156. The land description reads the same as the previous deed, with the north line running south 60 degrees west and hitting on the ridge between the left-hand fork of Bailey Creek and Turner Branch. It reads, beginning at a cross fence above the house where Nolan now lives, a conditional line between Moses Turner and Nolan. Then with said cross fence, a straight line to Nolan's north line. Then down with Nolan's north line to a dividing ridge between Bailey Creek and Turner Creek. Then down with the ridge to the Clover Fork. Now we have two deeds with the same description, with the north line running south 60 degrees west in a straight line hitting the ridge between the left-hand fork of Bailey Creek and Turner Branch. Notice how staying within the requirements from the patent description of a south 60 degrees west angle for the north line, while also ending that north line on this ridge as described in both deeds and the patent, prevents the north line of this 1,800-acre James Turner patent from moving any further north than this placement. If you try to move this south 60-degree west line further north, the ending point of this line ends up on the other side of the Black Mountain Ridge, where the ridge between the left-hand fork of Bailey Creek and the Turner Branch is non-existent. The Hensley family asks, how then is it that JRL and HBKY surveyors move this north line further north, encroaching and essentially taking acres of land and minerals away from the Hensley family, whose property lies here on the north line of the James Turner 1,800-acre patent? This ridgeline between these two creeks runs north and ends here. Again, moving this ending point for the south 60-degree west line further to the north, as JRL and HBKY surveyors do, puts the end point here and thereby moves the whole north line of the James Turner 1,800-acre patent way over the high Black Mountain Ridgeline, two ridgelines and creeks that flow north and have different names and different owners on the other side of the high Black Mountain Ridgeline. This goes against the description of this line in the deeds owned and sold by and between James Turner's children, Moses and Louisa, that state specifically how the north line of the James Turner patent ends right on the ridge. Any further north, and it would be ending where the ridge does not exist. JRL and HBKY surveyors fail to clearly include the location of the Black Mountain Ridgeline, which is basic to the correct placement of this line. One might argue that Google Earth is not a land surveying program. However, with this particular dispute, a surveying program is not needed because the most important factor is the ridgeline that serves as a landmark that has existed, again, for over 1,000 years. We will show that the landowners in the 1800s also corrected this Cumberland Valley Land and Mining Company survey that also took the end of this north line too far north. The information box here covers and blocks the Black Mountain Ridgeline, which is the most important landmark in the property line dispute. The Black Mountain Ridgeline is not even labeled on this survey, nor are any of the other labels for ridges or creeks that are needed in order to properly place the James Turner 1,800-acre patent north line. This is the whole entire reason for the survey. The James Turner 1,800-acre patent is mentioned here, but the line is not clearly identified. In fact, if this is the line that is supposed to be the James Turner 1,800-acre patent, we ask why it ends here, because the full length of the north line is 740 poles, extending far to the east. 5. William B. Kelly and his wife, Jane Kelly, kept this tract in the northwest corner of the James Turner 1,800-acre patent for almost 13 years. Then they sold just the northwest portion of it to the Cumberland Valley Land and Mining Company from New Jersey on August 8, 1887. This conveyance is recorded in the Harlan County Courthouse in Deed Book K1, page 164. The surveyor for this tract of land used a new and different placement of the north line, and the northwest corner of this James Turner 1,800-acre patent was moved much further north. The line was moved north, encroaching on the patents of these patent holders on the north side of the mountain. With this measurement of the James Turner Sr. 1,800-acre patent, it would actually measure over 2,800 acres, exceeding the number of acres on the James Turner warrant by over 1,000 acres, which clearly goes against the statute of the court order warrants. How could a surveyor make such a big mistake? This article explains how and why measurement mistakes were made in these days. As stated here in this caption, the error resulting from the measurement on the slope rather than a horizontal distance is shown in the figure above. The steeper the slope or the longer the distance, the greater the error. When the survey from the Cumberland Valley Land and Coal Company conveyance encroached on the neighboring patents to the north of the James Turner Sr. 1,800-acre patent, it took the measurement of this patent to 2,964 acres, which would be over 1,000 acres more than the 1,800 acres that was called for on the warrant. Even when the north line of the James Turner Sr. 1,800-acre patent hits right on the Bailey Turner Ridge, it measures in excess of 669 acres. Number 6. On April 3, 1888, a correction deed for the October 3, 1874 deed was filed, stating that the northwest corner of the James Turner 1,800-acre patent hits on the ridge between the left-hand fork of Bailey Creek and Turner Branch, making the James Turner patent 1,800 acres instead of 2,800 acres, and making it impossible for the northwest corner to hit any further north of this point, because this ridge does not go any further north. It ends here. 7. Chadwell F.C. Nolan owned this 150-acre patent here, which was granted to him in 1866, number 37897, recorded in the Land Office Book 86, page 508. As you can see, the erroneous measurement of the Cumberland Valley Land Company caused the James Turner Sr. patent to overlap onto Chadwell F.C. Nolan's patent, who was the son-in-law of James Turner Sr. and the brother-in-law to Moses Turner, the son of James Turner Sr., who had received this northwest corner tract from his father in his will. 6. On April 3, 1888, a correction deed for the October 3, 1874 deed was filed, stating that the northwest corner of the James Turner 1,800-acre patent indeed hits on the ridge between the left-hand fork of Bailey Creek and Turner Branch. The correction deed is recorded in the Harlan County Courthouse in Deed Book K1, 418. 7. Chadwell F.C. Nolan, Kentucky congressman, owned this 150-acre patent here, which was granted to him in 1866. As you can see, the erroneous measurement of the Cumberland Valley Land Company caused the James Turner Sr. patent to overlap onto Chadwell F.C. Nolan's patent, who was the son-in-law of James Turner Sr. and brother-in-law to Moses Turner, the son of James Turner Sr., who had received this northwest corner tract from his father in his will. As you can see, Deed Book K1, page 415, the re-recorded correction deed for this tract, had corrected the mistake measurement and moved the 1,800-acre Turner North back to the correct placement, with the northwest corner on the ridge between the left-hand fork of Bailey Creek and Turner Branch,
allowing for the eventual accurate sale of this tract and patent. In 1906, Chadwell F.C. Nolan and Louisa Turner sold this patent to Carter C. Howard and his wife, Martha Lewis Howard, in Deed Book 9, page 462. Martha Lewis Howard was the first cousin to the mother of Mary Turner Lewis, who was the daughter of Moses Turner and the granddaughter of James Turner Sr. They were clearly making sure things were handled fairly. On September 6, 1906, Carter C. Howard and Martha Lewis Howard sold this tract, along with their own patent for 50 acres, to the Cumberland Valley Land and Mining Company. This deed is recorded in Deed Book 9, page 500. At this point, for the first time in over 40 years of conveyances in this area, an additional patent for the same man, James Turner Sr., begins to be mentioned in deeds conveyed on the same ridgeline. Because this patent is the oldest, it essentially lies underneath all the rest of these patents and deeds. It is the most senior patent, meaning it governs the property lines and takes precedent over the rest of these patents and related deeds. Figuratively, this patent becomes the center of attention for the next 8 years, as it is mentioned in the next 13 deeds along this ridgeline. Because this patent was granted in the name of James Turner Sr., all of his children and now grandchildren, in addition to everyone who had received this land by deed, would have an interest in this patent. This must have been a surprise to everyone that after 66 years of being forgotten, it was uncovered. This begs the question of who discovered this patent. We have made an educated guess that it was Chadwell F.C. Nolan, who had 2 train stations named after him, where he surely caught the train to Frankfort. Chadwell F.C. Nolan had access to the land office, where all the patents are stored. He was a representative for Harlan, Bell, Perry, and Leslie County, and was an active adherent to the construction of a new state capitol building. He introduced a bill that would change the name of Harlan from Mount Pleasant to Harlan as the Harlan County seat. Was he the person who discovered this oldest 200-acre patent owned by his father-in-law in the land office in Frankfort? We may never know who discovered this patent and initiated the correction process called a moiety to resolve the discrepancies between several patents and deeds, but we do know that it is a legal patent that is still filed and active to this day in the Secretary of State's land office in the Capitol building in Frankfort, Kentucky. The 13 deeds that mention and describe this 200-acre overlapping senior patent tell the story of how these neighbors, family members, and attorneys worked together to agree, resolve, and correct this discrepancy by filing deeds approved and recorded with the elected Harlan County clerk at the time, G.W. Howard. William Kelly Sr. and Jane Kelly, who bought this northwest corner from Louisa Turner Nolan, the daughter of James Turner Sr., and her husband, Chadwell F.C. Nolan, conveyed this east side of the gray area to our grandfather in a deed recorded in the Harlan County Courthouse in 1907, November 23rd. The tract in this deed is the basis of the dispute. It contains what is estimated by Pike Tech to be $28 million worth of coal. Negotiated at a typical lease would be $2 million for the landowner, the Hensley family heirs. For this west portion of the overlapping gray area, 2 trustee attorneys handle the conveyances of differing percentages for William B. Kelly, J.A. Creech, who had been given a portion for engineering work he had done, the James Turner descendants, and Lloyd Hensley along with his 2 brothers. As mentioned, Lloyd Hensley, our grandfather, bought this east side of the overlapping portion. The Hensley brothers jointly owned this patent that is the 200-acre Sam Howard overlapping patent, and this is the reason they were included in the moiety process. The descendants of James Turner Sr., who were residing in Kentucky as well as several other states, were contacted and participated by deed conveyance. All of these landowners with overlapping interest in the gray overlap used the moiety process to receive their interest in the overlapped area, and then they sold their portion to the trustees, J.B. Carter and H.C. Clay. Then it was sold on to T.J. Asher Coal Company. The Hensley brothers, who jointly owned this 200-acre patent that was part of the overlapped area as well, and the reason they were included in the moiety process, went ahead and sold their portion of the west side to T.J. Asher
Coal Company, who kept these deeds from 1914 to 1917 and mined on lower elevations because the equipment did not yet exist to reach this coal at this high elevation. Then T.J. Asher sold this tract along with the surrounding tracts to the Harlan Colliery Coal Company. The Harlan Colliery Coal Company then sold this west side of the Gray Tract to Eastover Land and Mining Company on July 25, 1970, the deed of which is recorded in Deed Book 185-205. Back in November of 1907, Lloyd Hensley could have sold his area of where the 200-acre James Turner Sr. overlaps his 200-acre Sam Howard patent, but he decided to keep it and ensure that this portion remained his property by purchasing it, essentially receiving this portion by deed and descent from his father, Henry Hensley, and also purchasing it from the Moedy process. The Hensley family contends that if it is determined that the Hensley family does not own this area on the east side of the overlap in the Moedy process, then it would also mean that JRL Kingdom does not legally own this portion on the west side of the overlap, because they both received this land from their predecessors. JRL Kingdom received this tract of land from the Moedy process that went to T.J. Asher Coal, to Harlan Colliery Coal Company, to Eastover Land and Coal Company, to Manalapan Coal Company, to Kingdom Energy Resources, to United Communications, to Kingdom Logistics, and then to the most recent deed, Kingdom Energy Resources. Through the same Moedy process, the Hensley family received the east side of the Moedy, here in green, passed down by will and descent from their grandparents, Lloyd and Mary Hensley, who paid taxes every year and kept the mineral rights and land intact. Again, from 1907 to 1914, the trustees handled an agreement from 27 landowners. The description agreed upon by these people and recorded in the Harlan County Courthouse definitively fixes the 200-acre James Turner Sr. patent and the 1,800-acre patent in relation to the high ridge line of the Black Mountain and the ridge line between the left-hand fork of Bailey Creek and Turner Branch. These specific measurements fix this north line of the James Turner patent here. By placing the James Turner 1,800-acre patent here, it seems that JRL Coal Kingdom and HBKY are attempting to disregard the corrections made by the 27 landowners and 2 trustee attorneys in 13 signed deeds recorded in the Harlan County Courthouse from 1907 to 1914, and instead move the north line of the James Turner 1,800-acre patent to an incorrect placement that's already been corrected once before. How do we know that the placement of the 200-acre patent of James Turner Sr. that was surveyed in 1842 and granted by Governor Robert Letcher in 1843 is placed correctly? Again, a surveying program is not needed to find the beginning point of this tract, because the beginning point is well defined in the original survey by the men who were in the survey team that day. It reads, beginning on a hickory and buckeye in the head of the left-hand fork of Bailey Creek. After plotting the calls in the plot program, the tract comes out to be very close to 200 acres, which is what is called for in the warrant. You will notice that the odd shape of this tract resembles an upside-down bird, with the beak here and the tail feathers here. It may sound a little funny, but it helps to remember this. The beginning point must begin in the head of the left-hand fork of Bailey Creek. This yellow star is the beginning point, and the tail feathers of the bird. If we move the beginning point south, we are no longer in the head of the left-hand fork of Bailey Creek. If we move too far north, then the beginning point is over the high Black Mountain Ridge and into the head of Big Rock Creek instead of Bailey Creek. This is as far north as we can move this survey and still keep the correct directional calls that are called for in the survey. Thanks to a surveyor at Pike Tech, we were able to correctly overlap this patent with the other James Turner 1,800-acre patent.
In 1910, the county surveyor, George T. Howard, even found a gap at the north line of this upside-down bird-shaped tract that had not been claimed, so he applied for and was granted a patent for 5 acres, which he put in his wife's name, Nanny Howard. This patent survey describes all the patents with the overlapping lines perfectly. He then sold this patent to T.J. Asher. Robert Asher also found a gap and was granted a patent here, hemming the west line of the James Turner 1,800-acre patent on the ridge between the left-hand fork of Bailey Creek and Turner Branch. The deed that our grandfather, Lloyd Hensley, bought out of this community overlapping moiety resolution process reads as follows: a certain tract or parcel of land lying in Harlan County, Kentucky, on the poor fork of the Cumberland River and bounded as follows to wit. Beginning on the top of the ridge, above the right-hand fork of the Big Branch, this is in relation to the flow of the Poor Fork River on the upriver side of that creek, Big Branch, on the line of an 1,800-acre survey made in the name of James Turner. Thence, down the top of the ridge to the north line of the 200-acre survey patented to James Turner. Now this description stops and refers to the patent of the 200-acre James Turner, and it states, this survey begins in the head of the left-hand fork of Bailey Creek, just as it reads on the 200-acre survey. Thence westwardly with the north line of the 200-acre survey to the top of the ridge below the right-hand fork of the said Big Branch. Thence southwardly up the top of said ridge to the 1,800-acre survey. Thence with the 1,800-acre survey to the beginning. This tract description identifies landmarks that, again, have been here for at least 1,000 years. There is no need for the problematic meets and bounds measurements with poles or chains that can be in error on steep slopes such as this ridgeline. Moreover, this description identifies all of the needed patents and the overlapping lines perfectly. We as a family are unsure why this tract of land is not recognized by JRL, Kingdom, or HBKY. In October of 1907, there was a federal case that went to the Sixth Court of Appeals, correcting the overlapping patent issue involved with several other overlapping patents with this 86,000-acre patent for Noble Smith, John Ledford, and Henry Skidmore, number 6975, granted on September 25, 1845. This patent predates the James Turner 1,800-acre patent by about 9 months. The Hensley family is requesting a similar examination of the facts in order to achieve a fair outcome in their case. 11. JRL Kingdom seems to refuse to acknowledge these 2 Hensley deeds and the patents they indeed own that are just north of the north line of the James Turner 1,800-acre patent. In 1971, the Eastover Mining Company did acknowledge that the Hensleys own these 2 deeds, as well as both of the correlating, overlapping patents, by including them in their coal lease with the adult children of Lloyd and Mary Hensley. The Hensley family received payments for these tracts at lower elevations. Then, in 1978, Norman Yarborough, the president of Eastover Mining Company, wrote to the adult children of Lloyd and Mary Hensley, stating that, I regret that we were unable to reach your mineral and to implement our plans to mine the same. In this statement, Norman Yarborough was referring to the coal that is involved in this dispute. The continuing refusal to simply acknowledge the property lines has cost the Hensley family over $60,000 in attorney fees, over $12,000 in survey fees, over 3,000 hours of research and preparation that could have been explained in as little as 3 hours by simply acknowledging the deeds recorded in the Harlan County Courthouse. That the Eastover Mining Company, the predecessor of JRL, did acknowledge in their contract with the Hensley family. The Hensleys submitted interrogatory responses at great expense when they were represented by counsel Graham Morgan. Now they are being asked to submit 3 more rounds of interrogatories before they're given opportunity to simply sit down and share their property deeds that have been duly recorded in the Harlan County Courthouse for over 100 years. The repeated false accusation that the Hensleys have refused and failed to meet for a mediation or arbitration further frustrates the matter. From the Hensleys' view, it is baffling how many delays, barriers, and obstacles have been used against them as they simply defend 600 yards on their southernmost property line that was willed to them by their grandparents, Lloyd and Mary Hensley. In summary, the corrections made by 30 people using 13 deeds in the moiety process between 1907 to 1914 corrected the northwest corner of the James Turner 1,800-acre patent
to the ridge between the left-hand fork of Bailey Creek and Turner Branch. It also corrected the overlapping issues made by the most senior 200-acre James Turner patent, placing the beginning point, as is stated on the original survey, in the left-hand fork of Bailey Creek. These two factors verify the property line placement of the Hensley tract from Deed Book 13, page 176, recorded in the Harlan County Courthouse. The Hensley property deed recorded in the Harlan County Courthouse as Deed Book 13, page 176, proves that the Hensley family owns the most senior portion of the patent for the tract of land described in the deed. It reads as follows: a certain tract or parcel of land lying in Harlan County, Kentucky, on the Poor Fork of the Cumberland River and bounded as follows to wit. Beginning on the top of the ridge, above the right-hand fork of the Big Branch, this is in relation to the flow of the Poor Fork River on the upriver side of that creek, Big Branch, on the line of an 1,800-acre survey made in the name of James Turner. Thence, down the top of the ridge to the north line of the 200-acre survey patented to James Turner. Now this description stops and refers to the patent of the 200-acre James Turner, and it states, this survey begins in the head of the left-hand fork of Bailey Creek, just as it reads on the 200-acre survey. Thence westwardly with the north line of the 200-acre survey to the top of the ridge below the right-hand fork of the said Big Branch. Thence southwardly up the top of said ridge to the 1,800-acre survey. Thence with the 1,800-acre survey to the beginning. The Hensley family hopes this presentation provides proof that the Hensley family heirs hold title to this tract because they own the oldest patent for this tract by deed of purchase in 1907 by their grandfather, Lloyd Hensley.